Senator Amosun as well here, and of course Ekpeyemi Bamidele and Senator Jibola Bashir. Thank you very much for being here as well. The President of the Court of Appeal and Justices of the Supreme Court, Honorable Justice Danban Mensem, represented by Honorable Justice Daniel Khalil, GCA. Thank you for being here as well. The Ministers of Cabinet rank of the Federal Republic of Nigeria. I've been told that we are really pressed for time. The ambassadors of foreign nations, we'd like to welcome Ambassador George Ogunta, the Justice of the Supreme Court, retired, former ambassador to the United Kingdom. We have as well present with us the Justices of the Court of Appeal, and also we have the Chief Judge of the Federal High Court, Honorable Justice John Soho, represented by Honorable Justice Anna Kay. The Justices of the various Supreme Courts, thank you very much as well. We have our Royal Fathers also in our midst, His Royal Majesty Oba Alayelua Sahid Elegushi. Thank you, sir, as well. And of course, the Oba Lawal, that's the Oniru of Iru. We have the chairman of Parastatals, the head of service of Lagos, Mr. Hakeem Muriokwala, the SANs present, members of the legal profession, and of course, heads of states, and of course the group MDs and the statesmen, the captains of industries, members of the press, ladies and gentlemen, and of course those of you viewing from home as well. I am standing on all existing protocols, and during the course of this event, we will acknowledge you on the multimedia screen as you arrive. So thank you very much for being here, and we formally welcome you.
Your equipment to execute judicial and public sector reforms are not only proven, but they are manifest as well as remarkable. It is therefore my pleasure, ladies and gentlemen, to invite His Excellency, the Vice President of the Federal Republic of Nigeria, Professor Yemi Osinbanjo, Grand Commander of the Order of the Niger and Senior Advocate of Nigeria.
And to the Governor of Lagos State, Mr. Babajide Sanwo-Olu, the Deputy Chief of Staff to the President, Mr. Olanipekun, our host and honorary, Chief Wole Olanipekun, OFR, Senior Advocate of Nigeria, and his dear wife, Chief Folake Sholanke, CON SAN. Honored guests, ladies and gentlemen, let me say how deeply honored I am to have been asked to chair this symposium of the WOC Justice Summit 2.0 in celebration of the 70th birthday of my dear Ebon, Chief Wole Olanipekun, Senior Advocate of Nigeria. If you look at Chief Olanipekun's photographs when he was 40, when he was 50, and 60, and now 70, it is evident that nothing has changed. He looks exactly the same. Part of many years, and the mother of his children, Erelu Asiwaju Omolara Olanipekun. Our dear auntie, whose unfailing love and support, he undoubtedly would have been far less successful. I've had many conversations with Chief Olanipekun through the years, and invariably we come back to the elephant in the room. Will the legal profession as we know it survive another 50 years, given the gridlock in processing cases through the courts and the question of integrity of the legal process, or better still, the integrity of the actors in the legal process? Regarding delays in Nigerian courts, the UK Court of Appeal, the United Kingdom Court of Appeal, had occasion to comment in the case of IPCO and NMPC in 2015, where a challenge to the enforcement of a Nigerian seated arbitration tribunal award came before the English Court of Appeal. The Court of Appeal referred to the delays in the parallel proceedings in a Nigerian court as catastrophic. and that it will take a further 30 years to resolve. Incidentally, the expert witness who testified on the delays in the Nigerian courts was a former Chief Justice of the Supreme Court of Nigeria, who testified that it will take 20 to 30 years to resolve a case in the Nigerian court. On the integrity of the legal process and its key actors, judges and lawyers, most of us know, most of us who are here and who have practiced in our courts and who still practice in our courts, know at least anecdotally that many important cases today are under a shroud of doubt as to whether the outcomes will be influenced one way or the other. I look forward to the conversations that we focus on the implementable ideas, not a rehash of the problems, as we are all experts at the problem already. So let me again congratulate my Egbon on his 70th birthday and to remind him that his best years are still ahead of him. And as the scripture says, the path of the just are like the shining sun, that shine ever brighter until the perfect day. And so it shall be with you, in Jesus' mighty name. May I therefore welcome all of you to this event and wish you a very enjoyable afternoon. Thank you.
Mr. Governor, I'm a size 58, just in case. No, I want to start with you, sir. We have the immediate past Vice-Chancellor, Lagos State University, and of course, an awardee of the National Order of Merit. And it's a great honor to have him here with us to deliver the keynote address on the theme of the summit, Implementing Justice Sector Reforms. Ladies and gentlemen, please do make welcome Professor Olanipekun Fagbon, SAN.
Mens sana in corpore sano, a sound mind in a sound body. Our prayer is that your legacy will continue to endure. Your Excellency the Vice President, in the course of my research, I can confirm that significant part of the resources of Chief Olanipekun has gone into humanity. So that is what you are making a reference to in terms of his bank account. It has gone to humanity. In dealing with the topic of this year's summit, I asked myself, what exactly is the intent of the organizers? The first edition of this great event, which was delivered by Professor Fidelis Odita, was on the keynote, developing an institutional concept of justice in Nigeria. The Vice President was at that event also, and the Vice President looked at a number of things which I've identified in that paper. I asked myself, what exactly is the guidance for me in terms of the presentation that I'm going to be making here today? I recognize that in the letter that was sent to me, they made note of the fact that, yes, I served as Vice Chancellor of Lagos State University, and we were able to achieve a number of reforms. In the 5 years of the tenure of that administration, there was no crisis for the 5 years. There was no break in the academic session of the university. Those who know LASU before will attest to that. And it was a time that the university became a World Bank Center of Excellence. So these were some of the things that were indicated in the letter, and I felt they were part of the things that they want me to make allusions to. Now I look at the area of eminent jurists, leading practitioners and scholars that have been put together to discuss the theme of this event. It is generally accepted that the essence of reforms is to focus on problems with the aim of rooting them out. The importance of stock-taking the reforms, on the other hand, is to identify where progress has been made and where much still remains to be done, with a view to improving on both the relevant rules and processes. What I've done here is to look at what have we achieved since 1999. That is the benchmark that we are taking. What have we achieved since 1999 in the area of reforms? On its path to development, the drivers of Nigeria's justice sector have not been short of vision and ideas of how to move forward to achieve incremental transformation. Like countries with trusted justice systems, Nigeria wanted a system that will expedite and make affordable access to justice, a system that will boast of swift service for all, irrespective of status. A system where the law will be administered and served by an incorruptible, honest, efficient, and intellectually sound judiciary and the bar. I have identified the thrust of the reforms in the paper. I have also identified that we are not short of champions of the agenda. If you have good reforms, if you are able to identify champions and they were able to put this in place, then what is the problem? But before we go to the problem, what has been the scorecard for us? Despite these meritorious efforts, it is undeniable that not much progress has been recorded in achieving the goals of the different reforms. Most of our work are still paper-based and have identified these problems. But it is important to mention the note of some of those individuals who have done the assessment. When you look at what Fidelis Odita QC did at the last summit, he said, rather than just a problem of justice, access to justice, what we have is a situation of exit from justice. Judges are now being regarded with disdain, while lawyers are fast becoming laughingstock or an endangered species. There is a report of the UNODC, and that report identified that the justice system in Nigeria, despite laudable reform efforts at federal and state levels, continue to face multiple challenges. Again, when you look at the index of the World Justice Project, Nigeria ranks 108 out of 128 countries, measured by the World Justice Project Rule of Law Index. Now, what are the gaps? I have identified 9 gaps that I feel are creating the problems of justice, access to justice in Nigeria. And I stated here that I'm going to deal with them superficially so that all the other discussants will be able to flesh them up in different areas. The first one relates to administrative disconnect. In relation to administrative disconnect, I make the point that the focus of justice sector reforms has been more in putting in place right institutions, infrastructure, and rules than on administrative executives who play critical roles in the field. And I made reference to 1 or 2 things. Registrars who receive applications from litigants and they don't put them in the records of the file. And cases that have suffered 6-7 months adjournment will further suffer adjournment. I've made reference to situations where schedules of court are not communicated to counsel, even though the registrars have the details of the counsel. I've made reference to the fact that adjournments at times happen simply because the records of the court are not complete and you have registrars who are dealing with them. I've made reference to the fact that appellate courts, counsel submit so many copies, 20-something copies, for 5 judges, 7 judges, and you find out that even in the records of the file, these documents are not there. So I ask myself, these are issues relating to attitude of those who are practicing these issues. Who should do them? And I made reference to the fact that if you go to the National Industrial Court, they have a process that works very well. They have a process at the National Industrial Court where your judgment, you get them electronically. Where when you are paid for service, your papers, the processes will be served without you having to stress yourself or suffer through anything. It is the mindset of the individuals who are carrying out activities out. And we need to come back to train them. In addition to training them, we must be ready to hold people accountable. And I made reference to the fact that what is wrong in having a deputy registrar, process services? And if there is a default in service of process, you hold that deputy registrar responsible. When people are held responsible and when people are accountable for what they ought to do, you will find out that they will do it differently. I went ahead, and the second point that I've made there, functionaries of the ecosystem of justice. Quite a number of presentations that I've made here this afternoon recognize that justice, the justice sector, is an ecosystem involving different individuals. I've made reference in this particular area to functionaries such as correctional officers, the police, and the rest of them, and I noted that they do not have the requisite training that they ought to have. In addition to that, those who are exercising prosecutorial decisions, you find a situation that people misact, and when they misact, there is no accountability. Nobody is held responsible when you take a decision that violates issues relating to plea bargaining. When you take decisions in relation to charges that should be placed before the court. At the end of the day, a man who who has been convicted of an offense ends up getting 5 years for something that runs into millions, whereas a man who has stolen a goat will get 7 years imprisonment. So you begin to ask yourself, where is this disconnect? Somebody has stolen billions. He's getting 4 years, 5 years. And they take it back to the time he was incarcerated. And eventually he will end up with 4 years. But somebody who has stolen a goat, because he's hungry, he's going to have 7 years. There is clearly a disconnect within the system. I made reference to challenge of technology in Nigeria. And I noted in this paper that challenge of technology is simply because we have given a bad name to technology. When you start from procurement and you don't procure a good product, you end up getting technology that is outdated as at the time you want to use it. Why is it that in the private sector, technology is working very well, but in our court system, technology is not working well? The process that Professor Yemi Osinbanjo left in 2005, how far have we gone from that process since the time we started? That is a challenge. I also made reference to mortar coils in enforcement of judgment. When you go to our court premises, you see quite a number of vehicles. You see a whole lot of things that have been done there in furtherance of execution of judgment. You begin to ask, both the judgment debtor and the judgment creditor, none of them is having justice. Because by the time those things are destroyed there, the judgment creditor is not able to have money's worth. The man who owns the thing from whom you collected it, what is he taking home? Nothing. So what is it that we are talking about justice in that situation? Then I went ahead to say that lawyers, we are responsible for perpetuating a number of inefficiencies in the justice sector. And I will make reference to, in every application for land, a lawyer will go to court and file an application for injunction. When you know that least pendants doctrine is there, anything done during the period will go to nothing. Why do you have to belabor the courts with application for injunction? I've made reference to the fact that as long as the client is ready to pay, you see that our lawyers will go to court and file any application. And you find out that our judges at times are handicapped in meeting these challenges, because at the end of the day, they are scared of frivolous petition. Because what it will take a judge to defend a frivolous petition that has been put against him is so much, he will fund the trip of the registrar to the Supreme Court. At the end of the day, if the matter is adjourned, he will come back to Lagos. No judge wants any frivolous application to be written against them. And the end result of that is a situation where they are not in control of their court as they should be, to discipline errant counsel who are mischievous with great respect. And I made note of the fact that when you go to countries like the US and the UK, if you file an application that is frivolous, or you do something that amounts to professional misconduct, the judge right there will start the sanction. It happened in the case of President Biden. The lawyers in Delaware who filed wrong applications, not only did the judge fine them and said they should pay for all the cost of all the lawyers that were involved on behalf of the state, they said they should go back for training, and they also handed them over to disciplinary committee. Those are the kind of things that should happen. If you file a frivolous application against a judge and it is found to be frivolous, you should mandatorily face disciplinary process. These things should not be tolerated. I made a point about judicial officers and the burden of justice. And I said, at the end of the day, you find out that our judicial officers, some judges don't sit at 9 o'clock. When they sit at times, they don't go through the process in a way that is congenial. They give impression that there is hostility. Yes, we have recognized that lawyers can do some things that are wrong, but we have also recognized that some of our judicial officers, they don't have that judicial instinct. You must recognize the fact that when you look at the training of lawyers, as at the time you are going through the university and going through the law school, you are not being trained to serve as a judge. You are being trained to serve as a lawyer. When you are serving as a lawyer, you are taking the position of, I am protecting the interest of my client. You are not taking the position of balancing situation, looking and putting it on the scale and being able to do your assessment. But we throw them in, After 2 weeks of sitting with another sitting judge, we say they should go and start the work. At the end of the day, giving them that judicial instinct is not going to work that way. So I've made the point in the paper. Then I said, the way we want to monitor lawyers, there is also a need to start monitoring our judges. And I made reference to the fact that sometime in the 80s, it was the early 90s, we had a magazine in Lagos. It was Squib magazine. I'm sure some lawyers will remember the Squib. The fear of the Squib was the beginning of seriousness. No judge will sit late because Squib will report it. If a counsel misconducts himself, Squib will report it. If a registrar does something that is not right, Squib will report it. But what happened to Squib? Squib was shut down. It shows a system that does not want to be monitored. If we continue that way, we cannot achieve justice at the end of the day. Complexity of appellate court rules. I made the point that when you are looking at our appellate court rules, and I made an example, the Supreme Court strikes out a man's appeal against death sentence on the ground that the notice of appeal was defective and incompetent, same having been signed by counsel to the appellant instead of the appellant himself. Because the process was signed by his counsel and not by the appellant, that is the basis upon which the appeal is found incompetent. Our courts have continued to draw a distinction between grounds of mixed law and fact, ground of law. And from time to time, the court will tell us that it is a thin line between some of these issues at times. I believe we can make less complex our court of appeal rules. I believe we can make less complex. Look at these issues that creates, because when you look at our system, a matter that has been adjourned or a matter that did not come up for about 3-4 years, when they say that the appeals that are being had now are appeals dating back to 2017, 2018, and they come to court in 2021, and then they are struck out for being incompetent because it's a ground of mixed law and fact and there was no leave taken before the court. These are issues that are destructive of justice. Then I made the point, the last one, the eighth one, I've run through 7 of them. The eighth one, Supreme Court. I have noted that there's a need for significant shift in the way our Supreme Court are looking at issues. The goal of justice sector reforms is to enable the law to achieve substantial justice. Justice is the goal and the spirit of law. Consequently, there is no reason why a court should not administer justice in every situation and according to law. I've made reference to 4 cases here. FRL against Ojikalu. I know it's a popular case that all of us know. Lucky against the state. Ode and Alaga. Adegbanke against Ojelabi. I'm only going to focus on one of them. I will focus on Ode and Alaga because the birthday boy, Chief Olanipekun, was in Ode and Alaga. He was for the appellant applicant. What happened in Ode and Alaga? The issue before the court centered on irregularity of service of the notice of appeal. Respondent did not deny receiving a copy of the notice of appeal. Respondent accepted service of appellant's application for leave to appeal at the same address. Respondent was served with the notice of appeal by substituted means based on an order of the court, and this was before the hearing of the appeal. Respondent filed and exchanged briefs of argument, which in itself is a waiver or in a way of the defect. The Supreme Court held that because there was no personal service of notice of appeal, the appeal was incompetent. And I said, historically, these cases are indicative that despite the mantra of the court not to sacrifice justice on the altar of technicalities, the Supreme Court, with very great respect to their lordship, have continued to show a rigorous adherence to inordinate legalism as against determination of cases on their merit. And I made reference historically to the Supreme Court in the exercise of its interpretative jurisdiction has always walked the talk of pushing mechanism in the law to the back while pushing substance over form. I made reference to the case of Ariori against Elemo, Ohuka against the state, Nasiru Bello and Attorney General. Thank you very much. You saw that my voice was cracking. Thank you. Up till 9 o'clock yesterday, I was at another place talking. Nasiru Bello and Attorney General. These were landmark judgments where the court made clear its intent to go to any length to ensure that the ghosts of the past will not stand in the path of justice, clanking their medieval chains. Distinguished ladies and gentlemen, Your Excellency, you need to read cases that were on when outside of jurisdiction clauses were on ground. And you need to see the bold decision of our courts to ensure that you need to do everything before you can oust their jurisdiction. They guard it jealously. Our Supreme Court can determine the shift. Our Supreme Court can change the attitude of counsel and can change the attitude in relation to justice. The Supreme Court, it's a legal challenge for justice when judicial power is solely focused on application of legal principles to the exclusion of adjudication based on policy. When the attainment of the good to be is obstructed by the preservation of the good that is, the man on the street becomes distrustful of the judicial process. The Supreme Court has a significant role to play in shaping the society, shaping history, and shaping attitude towards the judiciary and the justice sector. The apex court should never be seen or be perceived to sabotage justice or take decisions that will undermine public confidence in the judiciary, whether it is to fill in gaps left open by indeterminate law or overrule precedents or legal positions that will have the effect of citizens suffering injustice at the hands of the law, or even to rebuke counsel's unethical inclination to sabotage the law. The Supreme Court has a duty to ameliorate the simplistic rigor of the rules in the context of fact situations as they develop, and bring about a cultural shift to accountability at all levels of our justice sector. And I made a point. When some school of thought come up to say that the Supreme Court, that the judiciary cannot make laws, that it is stepping into the realm of the Vice President, sir. Sir, I want you to listen to this, sir. When the Supreme, people argue, some school of thought say that the courts cannot make law, that it is just to interpret the law. And then they say that the court cannot step into the terrain of legislating. When you have a bad law, the Supreme Court has a duty to interpret that law. It is the spirit of justice that the Supreme Court is looking for. And when the Supreme Court does that, the Supreme Court is not going outside its remit. What the Supreme Court is doing is interpreting in the line of justice, in the line that the man in the court, the man on the street, will leave the court premises happy and satisfied that justice has been done. So it is not the case that the Supreme Court is stepping in. Finally, I went into political leadership and passive implementation of reforms. And I noted quite a number of provisions that these are reforms that we have done, particularly in relation to correctional institutions. These are reforms that we have put in place, but we have not implemented them. There are quite a number of them, and I've mentioned them there. There is no time, so I must close up. Conclusion. The burden of justice is beyond the attributes of impartiality, equity, or fairness of the judge, which we most times try to generalize as justice. It extends to the multitude of state and civil society institutions in the justice sector with varied vested interests, who must equally play their roles with a clear understanding of the importance of their contributions. In implementing justice sector reforms, there were three key assumptions whose self-evident truth we concluded were clear to all. The first is that the moment we bring in best practice, we will achieve the desired goals. The second is that all critical stakeholders have an understanding of what is at stake, and at worst, what will be required is the upscale of their skill set and knowledge. The third is that all critical stakeholders will exude the right discipline and commitment. Day-to-day unfolding events have fiercely challenged these assumptions. The threat to reforms and the dividend of reforms are steeped more in our individual contributions as stakeholders. The reality confronting Nigeria at the moment is that of lack of enthusiasm for justice within the justice sector. It has outpaced holistic justice. To give legitimacy to justice, accountability for the action of every role actor within the sector is critical. Indeed, it is fundamental. In the final analysis, for as long as the justice sector fails to implement reforms that translates to real justice, the force of equity and fairness will itself incite changes in ways that are radical and beyond what we can generally anticipate. And in closing, I said this. What were the three things we did at LASU? That for these 5 years, 2016 to 2021, everybody was part of the project. Everybody ran the race. Three things we did. Strict adherence to rule of law and due process. It allowed us to be consistent and fair. Even if you are close to the Vice Chancellor, what you are not entitled to, you will not get it. And if you are a foe of the Vice Chancellor, if you see yourself as a foe of the Vice Chancellor, whatever it is that you are entitled to, you will get it. I don't need to go there. They can be asked. They will confirm it. 2, every member of the community was made to understand the vision and they became leaders in their respective corners. That changed the culture. 3, accountability became a watchword because we were very bold on discipline.